going to do oppressions and mismanagement, that is powers of the majority and the rights of the minority, and the sections that we will be dealing mainly are section 397 and section 398. This is chapter 8 of the company law portion which we will be covering today. The powers of the majority and the minority rights. In this lesson today, we are going to explain the concept of shareholders' democracy, the majority powers and minority rights. The lesson describes the principle of non-interference in detail along with its justifications and advantages. It also gives provisions for protection of minority rights and shareholders' remedy. The provisions under the Companies Act for prevention of oppression and mismanagement have also been discussed herein. Let us first tell you what is the meaning of the concept of separate legal entity. As has been already known, the company, when it is legalized under the Companies Act and has been formed as a corporate body, it becomes a separate legal entity, and then the rights of the shareholders are only limited up to providing capital and exercising their rights over the dividend and share of profit. They have then given the reins of management to the directors, and the directors are the people who are going to manage the company. Also, the vote is taken by the shareholders to decide at the meetings for the major decisions that could be taken. The concept of shareholder democracy in the present day scenario denotes that the shareholder supremacy in the governance of business and affairs of the corporate sector, either directly or through their elected representatives. The Government of India has been endeavoring to disperse the shareholdership as widely as possible to avoid concentration of ownership in a few hands. During the past 5 years, there has been unprecedented growth in the Indian capital market amidst introduction of variety of economic reforms. It is widely acclaimed fact that in any corporate enterprise, the shareholders are the owners, but in fact, they are seldom able to exercise ownership right except to cast some few votes at the AGM. Also, the turnout ratio of shareholders at such meetings is very less. Now let us discuss the powers of the majority. As has been emphasized earlier, the majority exercises powers through the resolutions. There are two kinds of resolution, that is a special resolution and an ordinary resolution. A special resolution is 3/4 of the majority present and voting, and an ordinary resolution is more than 50%, that is, since it cannot be in fraction, it has to be something more than 51%. Now, powers of the majority, it means that a company being an artificial person with no physical existence, it functions through the instrumentality of the board of directors, who is guided by the wishes of majority. Subject, of course, to the welfare of the company as a whole, it is therefore a cardinal principal rule of company law that prima facie a majority of members of the company are entitled to exercise the powers of the company and generally to control its affairs. This truly means that the majority is the one who is going to decide the functions of the company, where the business has to grow and in which direction the company has to accelerate. Thus, the majority of the members enjoy the supreme authority to exercise the power of the company and generally control its affairs. But this is subject to two important limitations. Now, what are those limitations? The first one being that the powers of the majority are subject to the provisions of the company's memorandum and articles of association. The memorandum being the charter of the company, the basic document which defines the periphery or the area in which the company can operate, and the articles of association is a detailed record of how the company's internal working has to be carried on. The second one is that the company cannot ratify any act which being is outside the ambit of memorandum is ultra vires of the company. Ultra vires means beyond the powers of the company. Now, the powers of the company, as has been described, they are being defined under the memorandum of association. So, the memorandum limits both in a positive and a negative manner where the company has to go. So, it cannot do anything which is ultra vires or beyond the powers of the company. The resolution of a majority must not be inconsistent with the provisions of the Act or any other statute, or constitute a fraud on minority, depriving it of its legitimate right. Now, the principle of non-interference. The principle of non-interference has been given under the leading case of Foss versus Harbottle. This actually means that in this case, where an objection was brought about by the shareholders for dealing with the assets of the company, the court actually abstained from interfering into the affairs of the company, telling that company is a separate legal entity and all the decisions will be taken by the majority, and a few scattered shareholders cannot bring about a case against a company. Now, the general principle which had been enunciated in this case was that according to the principle of company law, it is that every member holds equal rights with other members of the company in the same class. The scale of rights of members of the same class must be held evenly for smooth functioning of the company. In case there is a difference, this difference is decided by a vote of majority. Since the majority of the members are in advantageous position to run the company according to their command, the minorities of the shareholders are oppressed. Oppressed means being put in a position of pressure to submit to the wishes of the majority. Now, the court will not usually interfere at the instance of shareholders in the matters of internal administration, and will not interfere also with the management of the company by its directors, so long as they are acting within the powers conferred on them under the articles of the company. Now, what is the utility of this rule or principle which had been enunciated in the case of Foss versus Harbottle? The justification and advantage of this rule of Foss versus Harbottle is been laid down that it is the will of the majority which should prevail. On becoming a member of a company, a shareholder agrees to submit to the will of the majority. The rule really preserves the right of the majority to decide how the company's affairs shall be conducted. And so the main advantages: number one, recognition of separate legal personality of the company. That company is separate, it has to be run by the board of directors, and the shareholders are a separate people who are owners of the assets of the company. Then second one is need to preserve the right of majority to decide. So, by commonality, that is by majority, by wishes of everybody, congruence, etc., there will be the right of this majority which needs to be preserved. Thirdly, multiplicity of futile suits which will be avoided. If every shareholder has a right to speak, has a right to challenge, then there will be number of cases which will be put up against the company, and normal day-to-day functioning will be hampered in this case. Then is the fourth one, litigation at suit of minority rule, futile if majority does not wishes. Now, all this litigation will lead to a situation where majority does not want it. So, it should not be the minority which is allowed to make a case against the majority and against the wishes of the company. Now, this does not mean that the minority cannot have a say in the company, or minority has to undergo really harsh and oppressive treatment just because the majority approves it. There are a few exceptions also to the rule of force versus habottle. The supremacy of the majority does not, however, prevail in all situations. Over a period of time, certain exceptions have been developed. For example, where the directors have acted improperly and are guilty of misfeasance, they may obtain absolution of their sins by calling a meeting of the company and by making full and frank disclosure. If the majority absolves them of their guilt and forgives their sins, the minority really cannot do anything. But there are certain acts which the majority of the shareholder cannot approve or affirm. In such a case, any shareholder may sue to enforce obligations owed to the company as representative for corporate interest. In other words, the rule of majority is subject to certain exceptions, and thus minority shareholders are not left helpless, but they are protected by number 1, the common law, and secondly, the provisions under the Companies Act. Now, we shall be doing both the kinds of rescues in detail. Number 1 is the action by the shareholders in common law. The first one being the Ultra Vires Act. Ultra Vires Act, as I have already explained, it means the acts which are beyond the powers of the company. So, if a company is pursuing through the intention of the majority any act which is beyond the powers or ultra vires, and any shareholder notices it, then he can bring a suit against the company, can get an injunction from the court to avoid such an act. Then is the second one, the fraud on minority. There could be instances when a few decisions are again plastered or forced on the minority by the majority, which are actually fraud. Purchasing of shares forcefully, putting risky adventures at the stake of the minority shareholders, all these will constitute fraud. Then is the third one, wrongdoers in control. That means people who are actually responsible for all the wrongful acts are the people who are in power. That means either it is the management or it is the majority of shareholders who are the wrongdoers of the company. Such a case has to be brought to the notice of the NCLT so that the management could be changed. There could be some shuffling within the board of directors. Then is the fourth one, resolution requiring special majority. Sometimes there are few decisions which need to be taken by a specified majority. That means a special resolution which requires 3/4 majority, and there are some ordinary resolution questions which can be decided. If a question had to be decided by special resolution and has been done away with an ordinary resolution, then such a case could be brought to the notice, and hence it could go under the correction. Then is breach of duty. There are certain duties which are cast over the company for the benefit of the company in the corporate interest. If the company has deviated from such a duty and it has breached its contracts and agreements, then also the case could be brought against the company. Then is prevention of oppression and mismanagement. To prevent oppressive conditions and instances of mismanagement, the action can be taken by the shareholders. Then there are the statutory remedies which are under the Companies Act. The first one is the variation of class rights. Now, it has been told earlier that all the shareholders under one kind of class will have the similar kind of voting rights and other rights, but sometimes the class rights could be varied. Now, this can only be done through a majority vote, that is by special resolution 3/4 majority of the shares held. In case the minority does not agree to such a variation, then 10% of the minority can apply to the NCLT and reverse the decision. Then is the second one, the schemes of construction and amalgamation. Now, many a times the company is reconstructed, amalgamated, merged with an existing company or a set of companies. In such a case, the decisions could also be taken by the minority, and if they find such decisions not appropriate, then they can apply to the NCLT. And the third one is oppression and mismanagement. Now, oppression and mismanagement has been discussed under section 397 and section 398. The fourth one is alternative remedy to winding up. In case there have been existence of certain oppressive decisions being plastered on the minority, then it could be an alternative to the remedy in winding up. Then is the last one, that is investigation by the government under section 235. If there are instances of mismanagement, instances of gross negligence, bungling of funds, etc., then an investigation could be ordered by the government under section 235. Now, let us discuss the section 397 and section 398 dealing with oppressions and mismanagement. As observed in the preceding topic, that one of the exceptions to the rule laid down in Foss versus Harbottle is the right of the oppressed minority to get relief against the wrongful conduct of the majority. As Alfred Palmer rightly said, the liquidation of the company may result in the sale of its assets at break-up value without regard to the value of the goodwill or know-how of the company, and the minority shareholders who urged by the shareholders' oppression petitions for a winding up order may effect play up his opponent's game. This means that if the winding up order is proceeded with, that could actually harm the interest of the shareholder, because then there would be a distressed sale by the company, liquidation would follow, and the assets will be given away at throwaway prices, helping any other opponent company to acquire such a company, and then it will actually result in low value to the shareholders because of liquidation. The oppressed minority therefore are willing in such cases not to end the company but to mend it. Section 397 of the Companies Act 1956 is intended to give a remedy alternative to compulsory winding up in such cases. Meaning of oppression. The meaning of oppression as explained by Lord Cooper in Scottish case of Elder versus Elder and Weston Limited is, the essence of the matter seems to be that the conduct complained of should at the lowest involve a visible departure from the standards of fair dealing on which every shareholder who entrusts his money to the company is entitled to rely. It means that when the shareholders have given their money to the company to be invested safely, then they would really not like it to be winded up because of mismanagement and oppression. In fact, they would really want to get it mended and get a corrective action at the hand of the board of directors. Now, how to prevent this oppression and mismanagement? Oppression is dealt in section 397 and mismanagement will be dealt in section 398. Prevention of oppression. The first remedy in the hands of an oppressed minority is to move to the NCLT, that is National Company Law Tribunal. It provides that any member of a company who complained that the affairs of the company are being conducted in a manner prejudicial to the public interest or in a manner oppressive to any members including any one or more of themselves, may make an application to the NCLT by way of petition for relief. Following requirements must be satisfied for seeking a relief under section 397. Number 1, that the affairs of the company are being conducted in a manner prejudicial to the public interest or oppressive to any members. Secondly, that the fact justified the compulsory winding up order on the ground that it is just and equitable that the company should be wound up. Thirdly, that to wind up the company would unfairly prejudice the petitioners. So, all these three circumstances should be existing while a petition under section 397 is made. Now, on being satisfied about the above requirements, the NCLT may make the necessary orders for ending the matters complained of. It is to be noted that the oppression should be of continuous nature, as is suggested by the words are being conducted in a manner used in section 397. Hence, isolated acts of oppression or mismanagement will not give rise to an action under section 397. What does public interest mean? Now, public interest under section 397 would be giving a relief. Now, relief would also be available if the affairs of the company are being conducted in a way prejudicial to public interest. Public interest is a very broad term involving the welfare not only of the individual shareholders or of the country according to the economic and social policies of the state. The concept of social profitability is very much likely or akin to the public interest. Now, winding up order under the just and equitable clause. The other requirement is that the facts justify the making up of winding up order under just and equitable clause. The principle is that if there is a persistent violation of the regulations and statutes and an appeal to general body is not likely to put an end to the matters complained of by reason of the fact that those responsible for the violations control the affairs of the company, then it will be just and equitable to wind up the company. That means the wrongdoers are actually having the reins of the company, so it seems just and equitable to wind up the company as a whole. Winding up would unfairly prejudice the petitioners, that is the third point. Now, though winding up is justified, it would be no remedy for the evil sought to be remedied. Thus, in Albert Limited, the person in management made an illegal sale of the share held by the applicant of his voting power. It was held that the company was liable to be wound up on the ground that it was just and equitable to do so, but it would unfairly prejudice the petitioners. Hence, they were entitled to relief under section 397. Now, we discuss section 398, that is prevention of mismanagement. Section 398 provides for relief in cases of mismanagement. For a petition under this section to succeed, it must be established that the affairs of the company are being conducted in a manner prejudicial to the interest of the company or public interest according to section 398 1A, or that by reason of any change in the management or control of the company, it is likely that the affairs of the company will be conducted in that manner, section 398 1B. If the court is so convinced, it may, with a view to bringing an end or preventing the matter complained of or apprehended, make such order as it thinks fit. There should be present and continuing mismanagement. The charges of mismanagement in the past, even if proved, are not enough to establish an existing injury to the interest of the company or public interest. Who can apply under section 397 and 398? Now, the number of members required to make an application under section 397 and 398 is given in section 399. It provides that where a company has a share capital, the application must be signed by at least 100 members of the company or by at least 1/10 of the total number of members, whichever is less, or by any member or members holding not less than 1/10 of the issued share capital of the company. Now, if the company has no share capital, the application has to be signed by at least 1/5 of the total number of members. The central government may, however, allow any member or members to apply if in its opinion circumstances exist which make it just and equitable to do so. That means the above rule can be disregarded if it is just and equitable according to the central government, and any member can make an application under this clause. Now, let us discuss the powers of NCLT under this section 399. Powers of NCLT are fairly wide. In fact, the court may make an order for the regulation of the conduct of the company's affairs upon such terms and conditions as may, in the opinion of the court, be just and equitable in all circumstances of the case. The powers of NCLT under section 397 and 398 may provide for: number 1, the regulation of the conduct of the company's affairs in future, the purchase of shares or interest of any member of the company by other members or by the company. Thirdly, in the case of purchase of its shares by the company, the consequent reduction of its share capital. Fourthly, the termination, setting aside or modification of an agreement between the company and managing director or any other director and the manager. Setting aside of any fraudulent preference made within 3 months before the date of application. Any other matter for which, in the opinion of the court, it is just and equitable that provision should be made. The termination, setting aside or modification of any agreement with any person, provided due notice has been given to him and his consent obtained. Now, what will happen of the already existing agreements with managers, managing directors, other directors, if such a decision of setting them aside is taken? So, we will discuss the consequences of termination or modification of agreement. Section 407(1)(b) of the Act states that the consequences which follow upon the termination, setting aside or modification of agreements between the company and its manager, managing director under section 397 or 398, it provides that where an agreement has been terminated, set aside or modified by the order in respect of manager, managing director or other directors, such person or persons cannot claim any compensation or damages against the company for the loss of office or any other respect. The powers of the central government to prevent oppression and mismanagement. Now, this is in addition to NCLT's power. Even central government has some powers to prevent oppressions and mismanagement. The central government may appoint such number of persons specified in writing to hold office as directors thereof as is necessary to effectively safeguard the interest of the company, its shareholders or public interest for such period not exceeding 3 years on any one occasion as it may think fit. If the NCLT considered necessary to make appointment in order to prevent the affairs of the company being conducted either in a manner which is oppressive to any members of the company or in a manner which is prejudicial to the interest of the company or to the public interest. Now, where not less than 100 members of the company or of the members holding not less than 1/10 of the total voting power therein apply to the NCLT, and on receipt of such application or on a reference made to it by the central government, make such inquiry as it deems fit to make and found necessary to such appointment. So, this has been covered under section 408(1). Few powers to prevent the changes in the board. Manager or managing director or any other director of a company is empowered to complain to the NCLT that as a result of change which has taken place or is likely to take place in the ownership of any shares held in the company, a change in the board of directors is likely to take place, which if allowed will affect prejudicially the affairs of the company. In such a case, the NCLT may make inquiry as it deems fit on complaint, and then direct on being satisfied that a resolution be passed or no resolution be passed or no action may be taken to effect change in the board of directors after the receipt of complaint. With this, we are concluding today's lecture. In this session, we had discussed about the rule of majority, minorities' rights, the rule of majority in Force versus Harbottle's case, NCLT's powers to correct the oppression and mismanagement, central government's powers, and section 397 and section 398 dealing with oppression and mismanagement in detail. I hope you enjoyed the lecture. Thank you.